Here's we trickle past 9:30. Normally with Laura Dwyer and Bill Schlecke. Today Jackie Austin sitting in. They're on assignment.
Yeah.
Good morning, Jackie.
Hi, how are you?
Good.
Good. Well,
what's cooking today?
I brought another guest with me. I like guests during my shows.
Good idea.
Yeah. So I brought with me Rick Mills. He's an attorney. He specializes in estate planning, charitable gift planning, and probate. And all that stuff has a lot to do with real estate. So we kind of got together and thought that would be a good topic for today.
Good topic.
So, hi, Rick.
Hi, Jay.
How are you?
I'm doing well. How are you?
Good. Well, I'm glad you wanted to come on the show. So.
My pleasure.
So tell me a little bit about what you do. So.
Well, we primarily represent families to plan their estates, and as well as any charitable gifts that they want to do, and we help them to administer probate estate when loved ones pass, and anything pretty much that goes through the doors of the probate court. So guardianships, conservatorships. Anything when you're dealing with a loved one that may be vulnerable and needs assistance, be it at a stage where we can draft documents for them, or if unfortunately they're at a stage where we need to go to court and get the court's authority to look after them.
Okay. So, so if we tie this back into real estate, clearly when somebody owns property, they have the title to it, and that's obviously got to be a big issue for estates. What are some of the things people should be thinking about when they're planning their estate and stuff like that?
Well, oftentimes for probate estates, the real estate is the only asset.
Mm-hmm.
So many property these days we can designate a beneficiary for. Or sometimes folks put joint owners or put property in trust. All ways to, as people talk about, avoiding probate. Oftentimes the house is one thing that does not avoid probate, and sometimes probate gets a bad rap these days, and it's much more streamlined than it was in the past, and I certainly do try to get my clients to avoid it if they can. But that said, it's not as terrible as you often hear about. Oftentimes people talk about how all the lawyers in the court and took all of the money from the estate, but that's a contested estate, which I'm sure you've seen those in your experience. And but in uncontested matters, probate's not the end of the world. But as I said, we do try to avoid probate when we can. We try to there's basically three major ways you can avoid probate with real estate.
Okay.
One way is to put the property in trust, and a trust for many reasons could be a good option. It's not the tool for everyone, but it's one of those things where it's often a good tool for many middle class and certainly wealthy families that is the preferred means. You can also put someone on the title. That's very common. If you talk to most estate planners, they'll warn you about the risks of that. Mm-hmm. But it may be appropriate in many cases. There's also an option that I'm sure you've seen that is not so widely known, and that's what's called a ladybird deed. I'm told a professor used the example of President Johnson and Lady Bird Johnson, and that's where that comes from.
Yep.
And I describe that as sort of a beneficiary designation on your land.
Okay.
It's relatively new. Really, probably the last 20 years that we've seen those, and it's sort of like naming a beneficiary like you would on your life insurance for your property. And the major benefit is we've always had what's called a life estate, where someone has a right to keep the property for their lifetime, and then when it's left at their death, it goes to whomever they name. There's reasons. Medicaid is problematic with that, and there's lots of reasons why that can be problematic. Whereas a ladybird deed, you really keep full title to the property. It's yours. You can sell it, mortgage, encumber it with a mortgage, give it away. I usually tell clients you can burn it down, but
probably not the best idea.
That's a joke. But you can, if it's still in your name at your death, it goes to your loved one, and it's not always appropriate. It sounds great, but it's really works. A pure ladybird deed, just naming an individual, is really only good if you have one, maybe two kids, and they get along just great. Larger families, that doesn't make sense. But oftentimes with larger families, we're looking at trusts or other
Yeah,
options.
and actually it's funny that you mentioned Ladybird deeds because we just started talking about those last year. I think Ron Ellison was on our show and he had seen one or two come through recently, and we talked about it a little bit. So yeah, it's a new term that I hadn't heard before last year, and now I'm hearing it again.
They're an awesome tool, and like, you know, one thing you'll probably hear from me is that not every tool is for every person. You know, it's a toolbox, and it's just like you have, you know, options as far as selling houses and financing options. You know, there are estate planning options, and there's you know, an attorney can find the right ones that fit your need. And oftentimes clients will come in and say, "Oh, I want a simple will," but a simple will includes all kinds of grandiose stuff that you can't do with a simple will. You know,
Right.
yeah, or they'll say, "Oh, I have a trust. My cousin has a trust," and they say they're just great. And I'll look at their property and say, "You know what? You're not going to get much value from a trust, and you're going to spend more money than it's worth to you." So, you know that.
Right. Well, what are some of the benefits of doing a trust? Because I see that all the time when I'm looking at property records. It'll be in the name of a trust, and you know.
Absolutely. Well, let's, if I may, let's start with what a trust is. I think
Okay.
that's a term we all have heard, but it's not often well understood. A trust, getting a little technical here, is a relationship. It's not really a thing. We talk about it like it's a corporation or an entity, but it's really I hold property in trust for you. I am the trustee, you're the beneficiary. I have obligations to you to make sure that the property is maintained, that it's invested properly, that it's insured, you know, etc. And a typical, what we call a revocable trust, is the kind that we use typically for probate avoidance. That's a trust where you're your own trustee, which gets a little confusing when I talk about being a relationship. You say, well, I'm trustee for my own self and for my own property, but when I die, my son is the trustee. And during my lifetime, I kind of do with the property whatever I want. I don't have to account to anybody. I really can, you know, have free access. But when I die, or if I become disabled to the point where I can't manage my own property, my son steps in, and then he has to be responsible to his siblings or to whomever is, you know, the beneficiaries are. And a trust, you know, certainly there's estate tax reasons why you'd want to do a trust. Those are becoming less and less a reason for many folks. We certainly have very affluent folks in town that need them, but much less than we used to because of the changes in the federal estate tax law. But there's always been reasons other than tax reasons why you have a trust, and for most of my, you know, middle class clients, those reasons are you know, really not driven at all by tax reasons, and they have to do with what you want to do with the property. You know, if you don't want kids to get property at age 18, which they always will if you pass the property through a will, you need to put it in trust. If you want to hold property, you know, for a period of time to assist them with their education, or if you want to make sure that you know, your plans are honored, you need to do that with a trust. A trust is also the best way to protect assets from a child. I use an example of a child, but any beneficiaries, creditors. You know, and we think creditors, of course, kids that are irresponsible with money, or if they have a gambling or a substance abuse problem, of course. But, you know, of course, anybody could have a catastrophic accident and have a major creditor, even though they're the most responsible person on earth. So creditor protection is always something we want to be concerned about. And
So no creditor could get into a trust?
well, the law, Greg, is interesting because I'm actually working on a probate. The probate section of the state bar has a committee that's drafting probate, you know, trust and estate laws, and one of the laws that we're working on is regarding what are called self-settled asset protection trusts. And self-settled means it's your money put in the trust, and because in Michigan, your trust property is protected from your beneficiaries' creditors. You know, if I put property in trust for my kids and then I die, and then, you know, and it says, you know, this is property is held for them, you know. Simply spoken, that's my money that I put in trust for them. It's not their money, and their creditors can't swoop in and take it. That's a broad statement, but
how, Rick? I guess my question: how would they protect it after the fact? Say the property turned into money, cash.
Yep.
Say they sold the property. Each kid got 25 grand.
if those funds are in trust and there's not a right to it,
would you have to have a separate trust account? Or
yeah, the trust would just own a bank account where the
Okay.
proceeds from the sale of the property would go, And if the trust does not call for immediate distributions, there's some discretion to the trustee. Then, if that creditor has a judgment against them and they garnish the trust account can't pay them. Them being the creditor can't pay them. So it protects that asset from the beneficiary's creditor.
Now, if they took that money, put it in their own account, then it's up for grabs.
Exactly,
Okay.
It's free game, and so we see that. Unfortunately, we see that with with divorces and with all kind, like I said, a catastrophic medical issues and all kinds of things where you would want to preserve that property, and so that's a big reason. Another reason is the fact that a lot of times clients own property in more than one state. So many of our snowbirds here have property in Florida and property in Michigan, and without a trust, you're going to have a probate estate in Michigan, and you're going to have another smaller probate estate in Florida, because only Florida courts have jurisdiction over Florida property, and you're going to have to hire a Florida lawyer because a Michigan lawyer is not licensed to do that. So you end up, jacking on their head, because we see lots of cases where out-of-state property can add complication. In fact, I have an estate right now for a Scottish subject who has real estate here in Jackson that he owns because of two deaths that were close together. One, a Scottish lady of Scottish descent who lived in Jackson and passed, and then her son, who was a subject who also passed shortly thereafter. And so that's getting very complex.
Yeah.
But your classic example, you have a condo you own down in Florida and you have your home in Michigan. If we deed both those properties into a Michigan trust, the Michigan trust can manage all of it. And you're avoiding the need of having to go to Florida and deal with their courts and deal with all the filing fees and all that.
Seems like that would be a big one if you are multiple.
Absolutely. In almost any case where we have property in multiple states, trust makes sense.
So let's talk about some of the other things that you talk or you deal with. So charitable gift planning. What exactly does that mean?
Well, charitable gift planning is an area that I get really excited about. I have the pleasure of serving on several boards in the community, and it's one of the more gratifying parts of my practice. And certainly that can be very simple in terms of bequest, which is just a basic gift in your will. I give $10,000 to the Cascades Humane Society, for example. That's what we would call a bequest. But with charitable gift planning can be so much more sophisticated and exciting when you're dealing with charitable trusts or what they call charitable gift annuities. All kinds of, you can make gifts from your IRAs, you can do all kinds of things, and I see that from the charities end, because I work with them often on a pro bono basis to plan their giving strategy in terms of how do they attract those kind of gifts. But also I can assist my clients in terms of how can they get the most bang for their buck as far as their gift. And oftentimes a carefully structured gift that takes advantage of tax planning, income tax being a big deal. Estate tax, as I mentioned before, is less of an issue for many people, but income tax is becoming a bigger issue with all kinds of, with the new Health Care Act, there's all kinds of new income taxes and all kinds of stuff. So that's a big deal. And you're wanting to, get that bigger bang for your buck in terms of taxes and do more for the gift, but also, leave a permanent gift. If it be a legacy at the community foundation, or if it's setting up an endowment, or those kind of things that if you have the means to do, you really can make a difference in Jackson.
Yeah. All right. So so we've talked about probate and things like that. I had an example this year. I sold a house that was actually really kind of different for me because I hadn't seen this before. I wrote an offer on a house. I was representing the buyer, and I get the response from the seller's agent that says, yes, we're going to accept your offer, but we have to close as soon as possible, which is fine for my buyer. She was paying cash, and she really wanted to get in the house anyway. But it turns out that the seller was actually very, very sick, and they thought that she may pass away before the closing date, and they didn't want to get into probate issues. So, that was a very interesting one. We actually were cutting it very close. I haven't checked to see if she actually ended up passing away, but they were very concerned about having to postpone the whole sale ultimately because she did pass away during the process.
Exactly, because if you have property just in your name when you die, and we haven't done all these probate avoidance things I've talked about, nobody else has authority to sell that property. No one can sign the deed. And so that's, you know, at its simplest, that's why we have probate, because the court has to say, Jackie, you know, I'm sorry your loved one was lost, but you need to be given authority so that business can be taken care of. And so, you know, if you go to, you know, the title company, they're gonna demand that an estate be open, and that letter are called letters of authority, which was the formal document that grants that authority to administer the estate property is given. And it, you know, it does take time. It at least takes a few weeks to get things going, and the estate lawyer is going to need the death certificate, and is going to, you know, it just takes a while. And so yeah, if you're right on the edge, it's good. And if you're any question of family squabbles, you know, most cases in what's called an informal estate, you don't need to go to court at all. I mean, everything's done through the counter and through filings. But
well, you don't see any family squabbles. Do you, Rick?
Rarely. You know, but when we do see that stuff, we are going to court. You know, I'm going to, you know, go to court in Hillsdale County here pretty soon to close an estate. It's not required, but it's one of those things where we want the court's blessing, the court to pass over everything. In this case, there's creditors are going to lose out. There's some kids that are going to get more than others just because of the way the probate law is, and we want the court's blessing on that. In most cases, we don't need to go to court for a probate estate when someone's died. Now, a conservatorship, which is someone managing property of another with court authority who is alive but is incapacitated, they can't manage their own affairs. By law, you have to get court authority.
Is there a simple way, Rick, to turn that property over? Say to your eldest sibling, if you're in the 11th hour?
If you're in the 11th hour, yes, you certainly can deed property over. One of the problems with elderly people we worry about is always with Medicaid. Anytime clients are talking about giving property away, you know, truly the 11th hour, that's not a concern. But if someone is just declining, and certainly if they're mentally declining,
yeah,
we do not want them giving property away without consulting with them, because well, two reasons. One is because they could give away property they don't have to give away for Medicaid eligibility. Certainly if they're married, they almost never have to do that. Or they're going to cause themselves to get a penalty. I'm sure many listeners have heard of you know, Medicaid penalizing people for giving property away. It's called a divestment, and basically if they penalize their mother, for example, for Medicaid, she'll be eligible for Medicaid, but she won't get paid. She won't receive she'll have to privately pay for her nursing home for a period of time as a penalty for giving her property away. You know? So it's one of those things where, you know, everybody will give you advice in that situation. Don't listen to it. You know.
Yeah. So
call Rick.
Yeah, call Rick. We're out of time. So Rick, what's the best way people can get a hold of you?
Well, if you call our main line, which is 517-513-8915, that you'll talk to Christine Cloak, who's my capable paralegal, and she'll be happy to help you. And we're also at millsprobatelaw.com.
Okay, great. Well, thanks for coming in. And I don't have any properties to talk about this week, anything in particular, but we do have properties out there. So call me if you see anything you want to take a look at. My number is 517-780-3800 or thinkingrealestate.com.
See you next week.
Thanks.
Brad Goldsmith here from American Jiffy Tax. I don't know if